Good afternoon, and welcome to the third session of our conference on the invasive other. I'm glad you're all here. I hope you had a chance, at least some of you, to be here yesterday with the two, I think, quite extraordinary panel discussions we had then. And today we have three. We have the panel right now on ideas, and then on invasive ecologies, and then at 6 o'clock this evening, we have the pleasure of Michael Ignatieff giving us our closing and keynote address. So it is my pleasure to introduce Dominic Petman, who I'm sort of astonished to say I really met he's my colleague here at the New School, and we literally met today. I mean, which is quite a kind of unhappy idea that we've been together and haven't met until now, but I'm very pleased to meet him. Dominic is chair of the Liberal Studies program at the New School for Social Research and professor of culture and media at our Eugene Lang College. He has published a great deal, many books, and his the most recent are Infinite Distraction, Paying Attention to Social Media, and a forthcoming book called Creaturely Love, How Desire Makes Us More and Less Than Human. That's a kind of tantalizing title. It's my pleasure now to turn it over to Dominic.
Thank you very much. So welcome all to the New School and to this conference. As was just said, I do teach culture and media, so it's very difficult to have a class without social media becoming front and center, no matter what the theme. This is our mode of communication these days. So if that's, the content can vary widely, of course, but this is the paradigmatic form of our age. And so the attendant metaphors of things going viral, etc., I'm sure will be one of the main topics today. My book on distraction, I'm thinking of the theme of invasion and how the generation gaps, even with people diving into their phones, especially the young, there's some strange parallel of the invasion of the body snatchers going on. There is this discourse about we have to get everybody's heads out of their phones, and that we're surrounded by pod people. And it's hard not to think that. And it's not even by age when you look around the subway platform, how we've just sort of been captured by these devices. And today we'll be talking about ideas, but an invasive. But that's fine. I lost my train of thought though. Anyway, so yes, the technology itself, the vectors itself, the modes of transmission themselves as being a form of invasion might be an interesting way to look at this. According to the most general axis, we have time. So if we're going to define an invasion or refute the definition of an invasion, that's often to do with at what point in history we decide something is indigenous or not, or immune or not. And of course, space. With ideas, maybe what plays the role of territory is the mind. So the polis of the mind, the territory of the mind. If you're going to be practicing digital hygiene, one of these phrases out there, then where is the boundary? Is it the body? Is it the mind? Is it the soul? Where is this shifting, blurring membrane between yourself and an idea? And this is another thing I hope we get to a little bit, is what counts as an idea as opposed to just, say, a unit of information or a meme or something like that. In the late 17th century, early 18th century, we had the Earl of Shaftesbury, who wrote a letter called Concerning Enthusiasm. And he writes about religious manias and panics, what today we might even call moral panics, and how these have a social and communicative aspect. But again, it's not the question of form versus content is something to bear in mind in this context, because is a panic an idea? Is an enthusiasm an idea? Can it just be a kind of a mode or vector or mood even of transmission, and very different ideas can be located, identified within that? So that's a very, very broad frame for today, and I'm not sure even how relevant it might be, but hopefully there's some connection there. So I'd like to introduce our three esteemed speakers who will be talking about the invasion of ideas. I'll introduce them all now. We'll have the three papers in a row so we can figure out the resonances between them, and then I'll throw open some questions. So first will be Dr. Agnes Callamard, who's the director of Columbia University Global Freedom of Expression, an initiative seeking to advance understanding on global freedom of expression, and special advisor to the president of Columbia University, First Amendment scholar Lee Bollinger. She spent 9 years as the executive director of Article 19, the international human rights organization promoting and defending freedom of expression and access to information. Prior to this, Dr. Callamard was chef de cabinet for the Secretary General of Amnesty International and their research policy coordination. And she has advised senior levels of multilateral organizations and governments around the world and led human rights investigations in more than 30 countries. Dr. Callamard has published broadly in the fields of human rights, women's rights, refugee movements, and accountability, and in fact holds a PhD in political science from the New School in social research. So the prodigal daughter here. Then we have Marc Rotenberg, who is the president of EPIC, the Electronic Privacy Information Center in Washington, D.C. He teaches information privacy and open government at Georgetown Law, and his work focuses on emerging privacy and civil liberties issues, and has litigated cases concerning airport body scanners, NSA surveillance, consumer privacy, government secrecy, and drone surveillance. Recent publications include Privacy in the Modern Age, The Search for Solutions, which is the new press of last year, and with Anita Allen, Privacy, Law, and Society, which is this year. And finally, last but not least, we have Jacob Silverman, who is a contributing editor for The Baffler, and his work has appeared in the LA Times, the New York Times, the Washington Post. And his recent book, I Need to Read, Terms of Service, Social Media, and the Price of Constant Connection. So please welcome our panelists today, and we'll start with Agnes.
Good afternoon, everyone. I hope you can see me behind that big platform. It's a pleasure to be here and to share with you some of my reflection on the topic that we're going to debate, which is the invasion of ideas. I will focus on what may constitute invasion in the digital era. I will focus less on what constitutes an idea, but we've already heard some thought about it. And I will look at a few examples to illustrate my thinking. Look at terrorism and ideas of terrorism that are being circulated through the digital means. I will look at the right to be forgotten as an idea, and more generally at human rights norm, very briefly, because time will be running out, based on the work I'm doing right now. And then I will conclude with some thought based on those three examples. So these were originally the three questions I asked myself when I was approached to contribute to this discussion. How much has the digital world transformed the world of ideas? How much did it transform the notion of invasion and invasive ideas? What are the invasive ideas of the digital 21st century and how different are they from the non-digital world? And equally important, how did the digital world transform, expand, or restrict the way invasive ideas are policed or controlled? So I won't get with in all those questions because time will be running out, but just to give you an idea of my thought process. Before going into the first example, I wanted to highlight the fact that historically, the ideals have always been controlled and policed. Of course, this is as central to state and society as the nature of governance itself. The debate around freedom of expression has always been a debate about what needs to be controlled and what kind of expression, what kind of ideas should be limited. And that debate has historically been framed as well around which ideas are not domestic, which ideas are not native, which ideas are not ours. Basically, which ideas do not respond to our way of being and our way of doing. So the idea of invasion and invasive ideas is quite central to the thinking and the practice around freedom of expression. I'm currently looking back again at the travaux préparatoires for the UDHR and the ICCPR, and it is very striking how much the notion of some ideas being invasive and having to be controlled is present there. On one hand, the Soviet Union at the time is looking at fascism as a form of invasive ideas that we ought to be protected against, and it's very central to the travaux préparatoires for the international human rights system. And on the other hand, you have the Western Bloc trying to protect itself against communist ideas coming partly from outside, but also from within. Their tactics are very different, and maybe in conclusion, I will go back to that. So ideas have got to be, need to be controlled, need to be restricted. This is the purpose of regulations around freedom of expression. And from the Second World War onwards, a number of international instruments have been established to determine which ideas need to be limited. And you have a range of international provisions under the human rights regime that seek to restrict freedom of expression. The most important one is Article 19 of the International Covenant of Civil and Political Rights, which determine that some ideas may be restricted if they have an impact on the respect of the rights or reputation of others, or indeed an impact on national security. I mean, it's phrased much more nicely than that. Ideas got to be restricted if they amount to propaganda of war, and if they amount to advocacy of national, racial, or religious hatreds that constitute incitement. Ideas that amount to incitement to genocide must be restricted as well. A lot of ideas related to the right to equality and non-discrimination ought to be restricted. At least that's the international legal framework. So all of this to say that internationally ideas, including ideas coming from outside or perceived as coming from outside or constructed as coming from outside, have always been the object of limitation by the state and through the state. Still, the digital world has radically or somehow radically transformed the state of affairs. So let's begin with the first example, which is very, very present in our daily life, which is violent extremism, terrorism, violent radicalization, incitement to terrorism, and so on and so forth. I just wanted to give you some ideas of what I am talking about here. So these are a succession of examples that's mostly from tweet accounts that are supposedly, allegedly amounting to the propagation of violent radical ideas. So I'm not going to get and try to analyze them all, but this is this one here is the main newspaper that ISIS is putting out on a regular basis related to its ideology and propaganda, and you can access it online. So plenty of examples of the use of social media by terrorist groups. I'm putting it in quotation mark, but I'm not going to use the word quotation every time. Just put it that it's my way of saying that there is no definition of what I'm talking about. So plenty of examples of ideas of terrorism, ideas described as amounting to violent extremisms being circulated via the digital world, and in particular via the social media, with a particular focus on Twitter, Facebook, and YouTube, and more recently, Telegram as well. So these are the means of communication. The size of the audience itself is difficult to assess. There was a recent attempt to close down all of the Twitter accounts which amounted to, or which were characterized as being an ISIS propaganda accounts. Most of them had no more than hundreds followers at a time. Still, there were quite a few of those accounts, but just to say that each account is not extremely popular. And the messengers themselves, there are a few messengers that are well known, but the majority are anonymous. That's how, just very briefly, how some of those things are communicated. So how has the state sought to respond and to control these ideas? They've sought to disrupt the message through a focus on the technology, to counter the message through counter speech, and to target the messengers through legal means. Disrupting the technology and the message, I think we may speak quite a lot about it. This is very specific, of course, to the digital era, and it's from takedown of website to denial of service to a range of technical means that are at our disposal to try to control those ideas from reaching out to a certain audience with more or less success, and we can return to that. But I think it's important to highlight the fact that there are specific means that were not, of course, part of the panoply of responses and the censorship system in place before the digital era. Counter speech is the attempt to countering those bad ideas, those invasive ideas, by providing an alternative to that speech. And I'll return to that in the conclusion, but what's probably interesting for our purpose is that the counter speech is being built as a speech from within. And the terrorist speech, the radical speech, is constructed as a speech coming from outside. And you will see that a lot if you analyze the various official discourse around it. So these are some examples of counter speech, some being driven by the state, others being more civil society driven, with, in my view, limited impact so far, but it needs to be continued. I want to spend a bit more time on the legal responses to these invasive ideas that are terrorism. What we have seen in response to not only the act of terrorism, but the propaganda, or what is being termed the propaganda, we have seen a multiplication of legal instruments coming out, starting with new laws being adopted around cybersecurity, but not only, and all the way to the prosecution of some of the messengers and new policies around the use of internet for the propagation of terrorism. So that's the work I do in particular. I'm looking at how those legal responses have been constructed. And here is a little summary of the key finding. So there is a quasi-global consolidation of national security as a legal and judicial framework as far as speech ideas are concerned. In my view, the result is a very broad and confusing legal area. There are broad, vaguely defined concepts and offenses, the granting of broad discretionary powers, and poorly argued jurisprudence most of the time. So what you are witnessing is the legal response is shifting from a focus on incitement and a nexus between the speech and the violence to a focus on the idea itself, independently of its potential for a violent act. So the nexus between the idea and the act has kind of disappeared over the last, I will say, 3 or 4 years, a little bit more here around 9/11. What you are also seeing is a multiplication of new charges that are related to the protection of national security against those ideas which are, again, not ideas with a potential for a violent action. They are just ideas we don't like. The potential for actions is actually very, very little investigated. And so the result is that, of course, not in Western democracies, at least until now, the result is that around the world, this expansion of the ideas that can be targeted means that people like the one you're seeing here, who is a very well-known Turkish journalist, is being accused of incitement to terrorism and actually propaganda, I think. And so are they. Those 3 people are academics in Turkey who have signed petitions against the human rights violations in Kurdistan, in the Kurdish part of Turkey. And they are all also facing, in fact, they are all in jail at the moment, accused of a charge with charges related to the petition itself, the idea that the petition had carried, which was not an idea of violence, which was not an idea of linking a potential, the idea with violence, but it was, in fact, questioning the use of violence by the state. So like I said, we are moving away from the causal link to violence, and we are seeing an increased focus on the perceived ideological and religious roots of terrorism. And that's a very big shift that you can see, including in this country, where, of course, the First Amendment should protect against that move, but that's happening, and that's, the US Patriot Act has allowed that to happen. But it's actually a global phenomenon. You must have heard about what the Turkish president has said recently around you cannot distinguish between a terrorist holding a gun and somebody just having a pen. And that, to me, is very reflective of what's happening to ideas that we don't like at the moment. Okay, so the focus is on extremism or on terrorism as a body of expressed thought and belief. And that's a major shift, and on extremists as deviant from mainstream and accepted social norms. Not because of what they may do, but because of what they think and may express, even if there is no relationship, even if the link between what they say and the potential act of violence is not demonstrated. So this is an example, a very interesting example. It's a French example, where this boy is 3-year-old, his mother and his uncle were sentenced to 6 months suspended jail for the T-shirt he's wearing. That T-shirt was seen by 2 persons, the school teacher and the school director. Okay, I won't get into the details because it's too much, and I think I may be running out of time. Just to say that some have argued, I think it may be a bit much, but some have argued that what we're seeing right now is a form of preventive prosecution around ideas. That is, defined as a policy posture involving aggressive employment of material support and conspiracies law to enable arrest without having to await the emergence of a specific plot. I think there may be evidence to it, actually. I didn't investigate that too much. What I did investigate is that in Europe, for instance, what you are saying in response to the invasive radical ideas is a focus on social cohesion within both the political discourse and the legal discourse. So courts in particular, including at the European level, the European Court, will argue their case around whether or not the ideas is a threat to the social cohesion. That's not completely new, but the way it's being used at the moment is certainly far more present in the jurisprudence than it has been so far. So for instance, wearing the niqab, which is a French case, which went to the European Court, and the European Court had actually really took their time to look at how bad that idea of wearing the niqab was. And they eventually concluded that it's not a question of security, it's not a question of women's empowerment and so on, it's a question of social cohesion, which I thought was very interesting if we look at what we are discussing today. Okay, well, that was for my first example. I'll just briefly look at the right to be forgotten. I don't know if you know about what it means, what it is. Am I speaking to an audience that knows? All right, so the right to be forgotten began, not really, but the first step is in Luxembourg. It's a European Court of Justice case where basically the court has determined that an individual, a Spanish man in that case, had a right to be forgotten, meaning it could be de-indexed from all Google searches. That, here what I want to say that this case came up in March 2014, so it's very recent, it's basically 2 years. And in the space of 2 years, that case has actually gone on a world trip, which you don't find very often. So I'm just showing that to you, how the jurisprudence of that case has gone and how it is resulting now in a fairly large map where the idea of being the right to be forgotten, which is an idea in and by itself, has become more anchored in many countries around the world, not in the United States, but certainly in Canada. And this idea is now getting into a third stage, which is very interesting for, again, the invasion purposes. The third stage is that the de-indexation has got to be global. Originally, the de-indexation was only to be done on Google.fr or Google.Canada. But recently, the French regulator agency and the Canadian court have said this makes no sense. If there is a valid right, a claim, if the claim to be de-indexed is valid, then it should become a global claim. It cannot just be restricted to Google.fr and Google.Canada. By so doing, what is very interesting is that basically both France and Canada have created an extraterritorial reach of their own idea, which is an idea that there is a right to be forgotten, against, some have claimed, the extraterritorial arm of US culture, which was embodied by Google. Just a third example, which is a very recent analysis I've done on all the cases I've analyzed in 2015 regarding freedom of expression. And I was in particular looking at how many of the lawyers, how many of the court decisions made reference to ideas outside their jurisdictions, meaning to jurisprudence or laws or standards that came from outside the national jurisdictions. And you can find here that 19% in total, but that hides a great deal of differences. So here, North America, the little green is Canada, basically. But none of the American jurisprudence is making reference to non-American jurisprudence, but look how that compares to Europe, where you have about 35% of all decisions making reference to non-European jurisprudence. And Africa is very large. So it's a continent which at legal and court level is very integrated within its legal global context, something I guess that the US Supreme Court Judge Stephen Breyer will be very happy with. If oh, I don't know what happened here. Oh, yeah, that's another global journey I wanted to show you, but time is running out. That's New York Times versus Sullivan, to show you how ideas can travel and can become foreign and invasive, but those ones are, of course, from my standpoint, benevolent ones. So this is clearly a little, okay. Very quickly, because I think I'm way over my time now, the concluding remark. So the internet world has, to a large extent, created a post-Westphalian world. It has, technology accounts for the transboundary and geography-defying quality of our world. And the human agency's interaction with that technology has solidified its geography-defying reach. So the state was originally not one of the agencies that were part of that new digital world. That's why it was described as post-Westphalian. So there were other actors involved. The technology was absolutely crucial. For some scholars, the users is the actor that played a crucial role in building that post-Westphalian world. For others, it's a transnational institution. For others, yet again, it is the corporation. So we were all living in this very lovely world, post-Westphalian, until summer 2013. Do you know what happened then?
Snowden.
Yeah. So what happened in summer 2013 is Edward Snowden revelation. I didn't have the time to put a photo of Edward Snowden, but you know all what he looked like. And his revelation points to the return in force of the state, seeking to assert control over what had been thought as the ungovernable internet. From my standpoint, I have to say that the centrality of the state to internet regulation and to the regulation of ideas on internet is not quite as new as some observers may believe. Already in 2006, I just want to quote Lessing, who is a very well-known, respected thinker around digital ideas. And he said the first generation of the architect was built by a non-commercial sector, the second generation was built by commerce, and the third, not yet off the drawing board, could well be the product of government. So that was in 2006. As a human rights activist, as it has been highlighted, working in the field of freedom of expression over the last 10 years, I have to say, to me, the state has always been quite central. The Chinese firewall is an example, but not only. There has been a multiplication of laws for at least 10, 15 years related to the control of ideas on internet. So in the field of ideas and in the digital era, the notions of geography and sovereignty have not disappeared. They've transformed, but not disappeared. They've been recreated for the purpose of digital control and digital policing. Indeed, these notions are central to the digital world. Just to give you the example of internet sovereignty, which is one of China norm that it's trying to sell on the international circuit with actually far too much success for my own taste than some would believe. But the notion of invasive ideas does not just apply to something that will be geographically defined, as China is trying to push for. The territories through which ideas navigate are not only defined geographically or by the state, and I think you were hinting to that, possibly very specific to the digital era. The definition of what constitutes invasive may simply mean what you, as an individual user, does not want to see. In the field of ideas, invasion can be policed individually. Both benevolent and malevolent ideas can be quite easily ignored. The internet does function as an echo chamber, if you want it to function as such. On Facebook, your friends may just all think and post like you. On Twitter, you can follow people who think like you. You may consult websites and watch videos that validate your views. Individual choices include the choice to close your mind, the internet revolution can and should open your mind to other realities, but it can as easily shrink it. And so here the invasive ideas are ideas you simply don't like. And for the first time in history, you have the means very easily to just create your own wall around those ideas. There is plenty of evidence that the internet assists in the creation of international virtual communities. So people across national boundaries create communities of interest and ideas, spreading such ideas, some emancipatory, some not so much. And so the internet allows individuals and groups to link to one another, both electronically and logistically, even geographically isolated people. So what you have through in the digital era, as far as ideas are concerned, is the construction of a community of ideas, community of people joined by similar ideas, but that community is not defined geographically. It's defined because of the ideas they have in common, the interests they have in common. And that is partly why it's so difficult to counter radicalization online. The concept of digital natives is something that we can elaborate upon. We should conclude just to say that I think maybe the other speakers will get into that. The policing is not just done by the state or by you, it's done by private corporation, and we may go back to that through maybe the terms of services. In conclusion, though, I'll say there is one thing that has not changed, and the historical pattern of an idea being labeled invasive because it's an idea that disturbs, that is still very much present in the digital era. Not because they originate from outside, but simply because we don't like them, simply because they disturb. They are the handmaiden of power, without which power is inconceivable. The control is an instrument to assist in the attainment, preservation, or continuation of somebody's power, whether exercised by an individual, an institution, or a state. That was there 2 centuries ago, 5 centuries ago, and it's certainly still here now. Thank you very much.
So next we have Marc Rotenberg of EPIC.
Well, hello, everyone. My name is Marc Rotenberg. I am director of the Electronic Privacy Information Center. We were established more than 20 years ago, actually, to focus public attention on emerging privacy issues. But we're also very interested in finding solutions to emerging privacy issues. That was, in fact, the theme of our recent book for the New Press, Privacy in the Modern Age, The Search for Solutions. I apologize, I don't have slides today, but I do want to call your attention to the image on the book jacket. We somewhat purposefully crafted an image that combined both the elements of the digital age, of the zeros and the ones, but also of social protest. And you'll see that there's a raised hand. And we did this to begin a conversation about how we confront and challenge new technologies, that we need not accept a technological imperative that technology necessarily enters our lives. And so I was very pleased to have the invitation to speak with you at a conference on the theme of the invasive other. Among the many topics we've explored over the last several years has been the growing presence of drones in the United States. And so I'm going to talk about drones today. They're non-military use. The military use of drones is a critically important topic, but it's not the focus of my comments. I'm going to talk about the deployment of drones in the United States, and I'm going to do this in 4 parts. I'm going to tell you first a bit about the technology of drones, what you need to know, a bit about the public policy implications, how we're beginning to discuss, assess, and evaluate drones in the United States. I'll share with you a fairly complex litigation strategy that EPIC has pursued over the last several years. We have multiple cases concerning drone surveillance. And finally, my goal is to fully engage the conference topic about the invasive other and raise the question, can we coexist with drones? What does it mean to live in a world of semi-autonomous devices, drones and robots and other types of technologies that begin to interact with us with their own purposes and consequences? Let's begin with a few words about what drones are. They're essentially aerial vehicles designed to operate without a human pilot. They typically carry sophisticated recording devices. In fact, it is almost a unique feature of a drone that will have a camera. This is not necessarily true for most aircraft. You can have crop dusters, helicopters, model rockets, all sorts of things that you might send into the air. They don't require cameras. Drones typically do. There's a great interest in the commercial deployment of drones in the United States. According to one report, there were more than 500,000 commercial drones in the US by the end of 2014, and that number is expected to increase for the foreseeable future at the rate of 15 to 20% a year. The next couple of years, we will have more than 1 million commercial drones operating in the United States. What are their uses? Well, of course, you've heard about some of the commercial applications. Perhaps Amazon will be delivering boxes to your doorstep with a drone. Journalists have talked about the use of drones to do investigation and oversight. Environmentalists are exploring the use of drones. There are even public safety applications, substituting drones for first responders. But the privacy and public safety issues are substantial as well. The drone technology is vulnerable to interception. The drone surveillance capabilities are not simply video, they are audio, they intercept electronic communication, they can do human identification at a distance, they can determine heat signatures inside a home. The policy dimensions of drones have fallen so far into roughly 3 categories: public safety, privacy, and registration. Public safety issues are interesting. It's a little bit more than a year ago that a drone landed in the south lawn of the White House. For a city that seems to be in a state of constant lockdown, the idea that someone could put a drone on the White House campus so casually was one of immediate concern. I understood recently that with the president traveling to London this week, the civil aviation authorities have simply announced that there will be no drone activity anywhere in London during this week. And that may be in part because at the beginning of this week, Monday of this week, in fact, the first reported strike of a commercial aircraft by a drone occurred within 6 miles of Heathrow. In fact, pilots are reporting an increasing number of near misses with drones in the national airspace. Over a 6-month period, beginning of this year, the end of last, pilots were reporting near misses at a level greater than 3.5 times per day. This was a significant increase in 2014 when the FAA began to record that number. It was less than 1 time a day on average. Even in the public safety applications, the use of drones have raised some concerns. When California had wildfires last year, and journalists thought it might be helpful to get some aerial surveillance of a very real public safety risk, the first responders, those who were going up in the air in helicopters, immediately became concerned about their own safety and refused to operate the helicopters intended to fight the fires until there was agreement from the journalists that the drones would not be operating in the airspace. Apart from the public safety dimension, the privacy issues are also very real. Drones, by their design, have the ability to do a form of pervasive and surreptitious surveillance that we've never before experienced. You could imagine, for example, seeing a person standing outside your home and taking your photograph and wondering, why is that person doing that? Perhaps if you've seen some of the images that have come off of Google Street View, you might be a little bit surprised to see how easy it is to capture and make public a person's image, even in a public space where there may be some expectation of privacy. But what you're probably not aware of is the ability of a drone on an ongoing basis to capture the images and do identification of hundreds or perhaps thousands of people at a political rally. And by the way, that activity might be very well justified to protect public safety, to identify individuals who may indeed pose a risk to a large public gathering. But you have simultaneously introduced a new technology that makes possible the rapid identification of people who gather in public places for a political purpose. Third issue, which came up rather quickly just before Christmas time this past year, is the registration of drones. What happens precisely when a drone causes an accident? When a person sees a drone operating on their private property, how is the person to know who the operator of the drone is? And so the FAA, out of concern that drones were going to be widely deployed after purchases on Christmas or leading up to Christmas, put in place a hastily crafted plan for drone registration, basically saying to the manufacturers it was sufficient if there were a serial number inside the battery compartment of the drone, so that in the instance that the drone caused an accident and you could physically identify it, lift it up, you would have a registration number and presumably some way to identify the operator. In the United States, central to the regulation of drones is the Federal Aviation Administration, the FAA, which has as its core competence the regulation of the national airspace and the protection of public safety. The FAA was told by the US Congress in 2012 to accelerate the deployment of drones to enable the more widespread use while simultaneously developing a comprehensive plan to address public safety and related concerns. The FAA has still not finalized its regulation and has not yet addressed the privacy issues that many organizations have raised. Yet it has simultaneously, pursuant to its 2012 authority, granted numerous waivers to drone operators, allowing them to operate drones under 200 feet in any part of the commercial airspace that's not otherwise restricted. Those waivers have typically gone to large companies, and they've been granted at an increasing pace. In September last year, about 3 years after passage of the Act, 1,700 of these waivers have been granted. I looked this morning, less than a year later, now about 5,000 waivers have been granted. So these are now drones operating in the United States, no longer subject to the public safety regulatory authority that the FAA had prior to 2012 to regulate those kind of craft. Let me say a few words about EPIC's litigation strategy now that I've described for you the technology and several of the public policy implications. We began looking at the capabilities of drone surveillance almost 10 years ago, because it was actually not long after 9/11 that the Department of Homeland Security and other federal agencies became very interested in a process that we might call automating surveillance. This includes surveillance of the borders. It includes surveillance within cities. It includes surveillance of parts of the country, major sporting events, and major political events where the Department of Homeland Security and others have concerns about public safety and enforcement of law. Through a series of Freedom of Information Act requests, we came to learn quite a lot about drones, the tremendous surveillance capabilities they have, their diminishing cost, their expanding range, the ability to keep drones aloft for longer and longer periods of time, and the surprising lack of oversight for their use by the federal agencies. We even had one Freedom of Information Act case concerning the giant blimp that was tethered a few miles north of Washington, D.C. It was a part of an armament system that had been developed in Baghdad. The two blimps operating together, one conducted surveillance, the other had weaponry that could be directed toward targets. And the introduction of J-lens just outside of Washington, D.C. was to begin to see if it were possible to move from the battlefield in Iraq to the nation's capital a similar capability. That project, as you may know, didn't turn out so well because the tether broke. The blimp went drifting off and ended up in a forest in Pennsylvania. Fled Zeppelin, we said. Okay. Freedom of Information Act and transparency was our first strategy. Our second strategy was a petition to the agency. We had 24 organizations, EPIC, ACLU, and a whole host of others, 50 experts, many members of the public, and we said to the agency 10 days after President Obama signed that act into law, facilitating the deployment of drones in the United States, that it should establish a privacy rule. At least make clear to those who are operating drones within the US that they have an obligation to some extent to limit the amount of surveillance. The agency sat on our petition for 2.5 years. In November of 2014, they responded by saying that they were going to consider the privacy issues in a rulemaking. We all were very excited, had lots and lots of proposals. And then in February of 2015, announced the rulemaking and said that privacy was outside the scope of the regulation, at which point we sued them. Wonderful Washington tradition. EPIC versus FAA, you'll find the case online. I argued in the DC circuit earlier this year, and our claim was very simple. We simply said that the agency, having committed to undertake a rule on privacy, its failure to do so was a violation of law, and the court should order the agency to do what it already said it would do. So we're now waiting for a decision. We'll see what happens. Third part of our litigation strategy concerns the registration issue. As I mentioned a moment ago, it's actually quite important to be able to readily identify autonomous devices that operate in the physical space adjacent to you. The registration scheme proposed by the FAA seemed the most minimal thing you could imagine. If you're a commercial airline pilot or if you're a ship captain, you know that when you interact with another plane or another vessel, you get to recognize the identity of the craft. And by the way, the same thing is true driving a car. You may not know who the driver is, but you do see a license plate on the car. Yes, we experience this every single day in our lives. When a car goes by, there is accountability for that vehicle operating in a public space to protect public safety. Drones apparently don't carry that obligation. According to the FAA, they could fly within 10 feet of you, perfectly permissible, and you would have no idea who the operator of that craft is. So we urged the FAA, in their consideration of the registration issue, to require drone manufacturers to actually broadcast, make easily accessible, open your iPhone, open the app that says, drone identity, and know right next to you, easily and at no cost, who's operating that mechanical device. FAA decided not to do that. We thought that was interesting. Then we learned that it was a secretive meeting of only industry groups, off the books literally. They didn't follow the government and the sunshine rules, and we sued them over that. That was our fourth part of our litigation strategy. So we've got lots and lots of interesting cases going. We're trying to establish accountability for the use of drones in the United States. Now, the last part of my talk, and I will be brief, is to engage this question of the invasive other. And I've been thinking a lot about this. You know, there's a tendency in the privacy world to say, well, you know, that kind of surveillance looks like a variation of that kind of surveillance, which is a variation of that kind of surveillance. But I've actually come to the view on this topic that something very different is happening, because we are beginning to deal with devices, as I've suggested earlier, that are semi-autonomous. And we're going to see more of this. We're going to see robots policing, you know, public streets, for example, in addition to drones flying overhead. And how do we talk about this? How do we think about this? Here are a couple of thoughts. Today, right now, between man and machine, we have an accountability asymmetry. It is very easy for a drone to recognize you, identify you, analyze you, determine if you have outstanding warrants, and have consequences for you. It is virtually impossible for you to hold that device to any account. And I think we need to change this radically. I think we need to put in place much clearer rules that establish our control over these devices that are entering our physical space. I am also concerned about what might be described as the automation imperative, because one of the things I have seen over the years in the realm of surveillance is that even well-intended people operating these systems, authorizing these programs, enacting this legislation, believe that they are able to keep these programs at a stable state without an understanding of the underlying dynamic, the diminishing costs, the increasing adaptability. Technology seeks application. It seeks purpose. And I think we're going to see that in this domain as well. We need to confront the very real scenario that we will move drone technology from a semi-autonomous realm, where there's a pilot on the ground operating a vehicle in the air, to an autonomous realm, where the pilot on the ground is replaced by a program or an artificial intelligence that has as its purpose a public safety articulated rationale for surveillance. Now, this is my concluding thought. Isaac Asimov very famously proposed the laws of robotics. And I'm going to read for you his laws of robotics. And then I'm going to propose two additions based on the need to challenge the presence of drones in our physical world. This is what Asimov said about robotics. He said, the first law, a robot may not injure a human being or through inaction allow a human being to come to harm. Second, a robot must obey the orders given it by human beings except where such orders would conflict with the first law. Third law, a robot must protect its own existence as long as such protections do not conflict with the first or second laws. These are perfectly fine ways to think about constraining the activity of an automated device in physical space. But I think we need to say more. So my additions to Asimov's law of robotics are as follows. A robot must always reveal to a human being its actual identity, a registration requirement on all autonomous devices. And second, a robot must always reveal to a human being the basis of its decision. algorithmic transparency. When a machine makes a decision, that should be made public. These are the ways in which we hold machines accountable. This is how we create expectations, not upon ourselves, but upon the invasive other.
Very much, Marc. And last but not least, we have Jacob.
Hello, thanks for having me. Can you hear me all right? Okay. I'm talking about the breakdown between public and private. If to really do this topic justice, you probably have to give a whole historical summary or exegesis on the history of privacy. But for our purposes, I kind of want to start more recently. And also we can talk about whether you actually think the difference between public and private should be talked about more as a breakdown or as a blurring of barriers or as something that's become rather permeable. I think that's worth thinking about too. My contention is more, I guess, that it's really whatever barriers might once have existed have really been rubbed away by digital technologies for reasons that I'm going to get into. And for a simple definition of privacy, though, I like to consider it as simply having some control over what people know about you and how you disclose personal information about yourself, having that right to disclose personal information, and having some autonomy and control, especially in social situations. But I'm also increasingly concerned about what I simply call data privacy, which is what machines and software programs, and sometimes the people who use them, know about us. But I think it's also, as some of the other speakers have indicated, especially important because many of these machines are either fully automated or semi-autonomous or really don't have that much oversight and might be making decisions or feeding decision-making processes without really any kind of human intervention or supervision. So I'll start by quoting a report from 1982. This was commissioned by the National Science Foundation. And they commissioned a think tank called the Institute of the Future, which was a spinoff from the RAND institution, RAND Corporation. And they were looking at the prospects for teletext and video text in the United States, which obviously didn't turn out very well, though teletext, I think, had a pretty long life in France and some other places. But it's, sort of an early internet type technology. And the quote is, "At the same time that these systems will bring a greatly increased flow of information and services into the home, they will also carry a stream of information out of the home about the preferences and behavior of its occupants." So that was about 34 years ago, and I think that's actually spot on. We live in a world of very much centered around personalized services, and certainly the quid pro quo of having those services personalized for us is that we increasingly reveal a great deal about ourselves, our habits, who we are, where we go. Pretty much anything you can imagine, we live under a system of practically automated 24/7 and an increasingly granular surveillance. And for a long time, the home itself, which this quote focuses on, was sort of an inviolable space. I mean, not everyone has privacy at home. Children, domestic workers, sometimes women or spouses in difficult relationships, all kinds of people don't really have privacy at home. But it's still generally thought of a general site of privacy. It's a kind of contained space. In the pre-digital world, we got some insight into what happens in people's homes or what people are up to through market research, census records, surveys, loyalty cards, credit bureaus, the work of government agencies. And there was a pretty flourishing industry of data brokers even before the digital era. But obviously we've had some profound and perhaps even revolutionary shifts with the move to digital technologies. The home has been made really transparent in a way that it's never been before. And now that we have these technologies like this old report predicted that are informing on what happens in the home, we also have those technologies with us, right? They've become mobile, so that transparency has really been applied to the human level as we take our smartphones with us and increasingly do more and more through our smartphone. That sense that we're always kind of reporting on ourselves is not only coming from the home and what we might be watching on TV or ordering to our homes, it's now also happening on the go and at our jobs and through our smartphones. And the smartphone, I think, is pretty key to all this and to this breakdown in privacy. It's become the universal prosthetic. Practically everyone has one. It's sort of become the Star Trek tricorder. It's this all-purpose tool that can kind of do anything. And even actually, if you're a Star Trek fan, you may have seen in some episodes they often take the tricorder and they're in some emergency or something like that, and they find some unexpected use for the tricorder. It powers some other device or gets the crew out of some disaster unexpectedly. We've almost seen something similar now, which is that our smartphones keep on acquiring new features, even when the hardware themselves are not being upgraded. There's a kind of feature creep. There are new uses being conceived for the sensors that are already in the phones, and then there are more being added each product cycle. So for example, now we have the various sensors in your smartphone being used for sleep tracking, for step counting, and for other forms of biobehavioral monitoring, and I'm sure that more are going to follow. And some of these were actually really conceived of not necessarily by the phone manufacturer or whoever put that gyroscope in the phone, but was a possibility that was thought of later by other people who realized that these sensors are actually quite flexible. And so I think that one of the other big factors we have to talk about with the role of the smartphone is also this general state of precarity that many of us live under, depending on whose statistics you believe. Up to a third of the United States may be precariously employed in some way or freelance workers. I'm certainly among them. So at the same time, you have this general state of precarity and also this growth of corporate power. And the phone itself has become this tool, and also the internet, which we access through our phones, that is always promising us something new, perhaps a way out of our current situation. You just have to refresh the feed and you'll find something new or some new possibility or opportunity, whether it's jobs, news, relationships, Uber rides, photos. Everything is done via the smartphone now, and often via the traditional feed that we're used to on social networking sites. The feed has become sort of the archetypal interface. At the same time, these feeds have been presented to us as unmanageable and always updated and kind of overwhelming, so we have to defer some autonomy or responsibility to the corporations managing our feeds, frequently by allowing them to do some algorithmic sorting, which is, of course, really upset Instagram users now that they've learned that their Instagram feeds are going to be algorithmically sorted pretty soon. And as someone else, I believe, mentioned, the phone certainly cuts us off from one another in public. One interesting thing, though, about the phone, I think, is that it certainly inhibits one kind of sociality, which is the face-to-face, in-person sociality. You don't really feel inclined to go up to someone with a smartphone and initiate a conversation. At the same time, it enables these other forms of sociality, but it's just all happening at a distance and mediated through the phone. You can actually be rather social through your smartphone and discover new social possibilities, but it's not happening in your immediate physical space, most likely. So through the phone and through the fact that we've all been made transparent, and that at the same time we're completely transparent to corporations and governments while they are rather opaque towards us, we find, I think, that digital surveillance and data analytics are actually the perfect neoliberal technologies, because what they really do is, besides compromising this boundary between public and private, is that they allow the market to be extended practically anywhere. And by that, I mean, really is that surveillance is the new business model, or is the preeminent business model for our tech economy. And so what you have to do to grow as a tech company is to find new opportunities for data collection, create new metrics, and also find new actions and behaviors to surveil. So the proliferation of smart devices could really just be seen as the proliferation of surveillance devices, I think. And I really think there's, at least in the current form, the current kind of paradigm and the way things are headed, there's no real way that personal privacy can stand up to this kind of thing, especially when surveillance is just considered kind of the cost of doing business or of getting these services, and that you have to submit to it. So a specific example we could cite is there was an interesting recent report in Bloomberg about Facebook. Facebook is worried about the decline in sharing. They claim that we're actually sharing as much as ever, but we're sharing a lot of articles and memes and videos and things like that. But we're not really sharing a lot about ourselves. Facebook cares a lot, of course, about personal sharing and knowing what you're doing. So Facebook actually told a journalist that there was a 20% decline in personal sharing year over year. To me, that was really interesting, not only because it reveals something very near and dear to Facebook, but also this way in which it was presented. Year over year, this 20% decline. It's almost the way that corporate profits or revenues are discussed. And you can see a real almost one-to-one relationship there, that corporate profits can only grow as long as sharing and surveillance and data collection grow. And actually, in that article, Facebook told the Bloomberg writer that they were worried about something called context collapse, which I thought was very interesting because for a number of years, a lot of media theorists and people who study this stuff have used that phrase, and I think it's actually a very useful term to kind of assess where we are now. In short, it's basically this notion that we used to have all different social environments and that our privacy was often determined by context and was very contextually dependent. But the consequence of networked digital systems, and especially social networks, is that our privacy is now more networked, and those contexts are less discrete, right? So for example, on Facebook, you're friends possibly with hundreds of people from all different facets of your life, from old boyfriends or girlfriends, to your boss, to close friends or family members. So there's a way in which these traditional social contexts break down or bleed into each other, and it's much harder to guard your privacy when there's this sort of intermingling between social contexts and really intermingling, I think, of data and surveillance systems and various monitoring systems. So Facebook is very late in the game kind of cotton on to this idea that people aren't always comfortable sharing to 500 people at a time who come from all these different contexts in their lives. To which I guess I can only say, I mean, I'm glad they're worried about this, but I wish it had come a long time ago. At the same time, I think we at least have to mention that there's been this massive growth, of course, in government surveillance, mostly unchecked. It definitely predates commercial surveillance, but is also deeply intertwined with it. And as we well know, government surveillance depends a lot on the existing systems of commercial surveillance, not only through cooperation with tech companies, but also subpoenaing tech companies for information or issuing national security letters, or sometimes outright hacking. Ad tech is sort of a field where the NSA apparently has had a lot of success hacking into various ad networks and and piggybacking on cookies that are kind of issued as part of a normal person's web browsing, and use those existing technologies which are supposed to facilitate a supposedly benign commercial surveillance. Well, we found that governments and intelligence agencies are able to appropriate them for their own purposes. And I think some of the general characteristics of this kind of environment that we need to pay attention to are that, one, it's largely automated. It's also very positivist, or encourages a certain kind of positivist thinking. The machine sort of feeds itself. It's dependent on a series of feedback loops. Often there's this idea that, at least through analytics or big data driven processes, that whatever conclusion comes out is right, that that correlation is all we need to know, that causation doesn't even really matter that much, technology is neutral, so we don't necessarily need to question the process. That goes along with, I think, a certain amount of algorithmic secrecy, or at least a lack of transparency about how these algorithms are often judging us. And in some cases, we don't even know, even the people using the algorithms themselves may not actually know. For example, there's the city of Fresno, there's a story about this, I think, in the Washington Post not that long ago, uses a predictive policing tool where threat scores are assigned to various addresses and people in the community, and cops who are sent to respond to a call might be given information about the threat score of the person whose home they're responding to. And there are all kinds of problems with this, not least the fact that the only people who know what criteria go into the threat score are actually the private company that makes the software that determines the threat score. So the cops themselves don't even know what goes into this, much less the person who's, the civilian who's on the other end of that police call, who doesn't know the criteria, of course, but also probably doesn't even know that they have a threat score. So through this system of surveillance really on an extravagant scale, we have a tremendous amount of behavioral monitoring going on. So not only our preferences are being reported about us all the time, but we're really being tracked on a 24/7 basis, and increasingly in a granular way. I mean, all the talk right now is about, it seems like, is about companies trying to track us between different devices and different environments. And it seems we're getting there. I expect we already have, of course, advertising following us around on the internet, but pretty soon we're going to have advertising following us around between our various devices, and perhaps even in the physical world, sort of the Minority Report outcome, if you've ever seen that film, in which different devices in public recognize people either by their faces or by optical scan, and customized advertisements appear in public. That's sort of this presented as this kind of horrible dystopic outcome in Minority Report, but it really seems we're not that far away from that. So, well, I think it's important to talk about this breakdown between public and private now, and some of the very deleterious consequences we've already seen in terms of bias, being different forms of racial and gender bias being incorporated into algorithms, a lack of algorithmic transparency. We've also seen things like the Facebook contagion study, or the use of differential pricing. I think there are other terms for it, but where you're charged a certain price on e-commerce sites based on personal information about you. So that started first basically just based on zip codes, but now it's increasingly getting more specific and more customized, where online retailers hope to charge you essentially the maximum they think you would pay in each situation. And all this I find very concerning, but I don't think, and this is perhaps a subject for debate here, I don't know if we've really seen what what coercion has looked like on a mass scale. I don't know if we've really experienced or seen that yet. For example, I wonder, there was this experiment the other day where a Russian, I guess a Russian activist, did an experiment where he took pictures of people in public and then used some sort of open source or publicly available facial recognition engine, and was able to identify more than 60% of the people just through their social media profiles. And that was pretty disconcerting, but then you have to ask what's going to happen in a few years when we all have a face print that we can't get rid of or change, barring some drastic measures, and we're all immediately identifiable in public by our faces, by these various automated systems from the government on down. Okay. So I guess one question is, how do we respond to this situation if these barriers between public and private have really been eroded? What do we do about it? I see a lot of people and scholars, experts in the industry. It's interesting now, a lot of them sort of talk like spies, and I think for a good reason, but we hear talk about attack surfaces or adversaries or threat models, or using OPSEC or COMSEC. And I think some of this stuff is very interesting, and certainly we want to promote the use of encryption and tools like that. And it's also important for dissidents, activists, journalists, artists, scholars, and many other people. But most people aren't spies, and I think the response for a lot of us has been sort of to securitize the self. This is kind of the smart, informed consumerist response, I think, which is that you use a Tor or VPN, you look into encryption, you opt out of whatever you can, you get ad blockers, things like that. There's just this whole sort of, I mean, one term for it might be cyber hygiene or digital hygiene, but it's kind of, I think, at least among early adopters, almost graduated more towards this kind of spy type mentality where we all have to be rather vigilant and paranoid, even if we don't necessarily have good reason to be. And there's almost, I think, a certain kind of machismo in it. And I think the obvious problem is that this isn't really tenable for most people. Most people don't either have the knowledge or the time or ability to kind of keep up with this stuff. But even so, even if you're perhaps one of the people in this room who is interested in these kinds of techniques and tactics and self-protection, even so, it still leads to endless cycles of maintenance, updates, charging, tending to your gadgets, securing them, researching them. I mean, recently, for example, I started using a program LastPass, a password manager to help keep track of all my passwords and try to create more secure passwords. And it's not as if I suddenly need a password manager for my password manager, but there is a way in which you start choosing one of these kind of meta-level tools to help secure and organize your digital life, which is to say really your life, in which they only keep compiling upon one another, or there are always sort of more updates that are needed, or more tools, or more ways in which you can be a savvy, secure user of these technologies. And to me, I think that just ends up being another form of consumerism. It really further entangles us in these very systems that we find so harmful. And I think one of the big problems of the current tech economy is that it's made us all into laborers, producing data and content for big platforms. And I think in some ways securitizing the self may not be more labor, but it certainly is giving into kind of the conditions set by the platform owners. It feels a little bit more reactionary and incrementalist and not radical in the way that I think we should hope for. Now, I don't claim that I have some kind of solution. At the same time, I think we should encourage very practical measures from government regulation to lawsuits that seek to improve things for the larger public. At the same time, I think as part of kind of this more radical thinking, or trying to think outside the current paradigm of simply adapting ourselves to these current conditions, we might also begin to realize that a militant rejection of certain technologies, even a kind of Ludditism, makes a certain kind of sense, but only, I think, if it's foregrounded in this kind of reasoning. You aren't necessarily rejecting technology, but you're rejecting surveillance capitalism, or the surveillance capitalism that's enabled and propagated by these technologies, or simply the really crappy politics of so many of the tech companies behind these technologies and services. Or you might also just be saying, I reject the consumerism and the labor that really goes into being a secure Facebook or internet user. Still, I do come back finally to this idea of what I call entanglement, which is just simply that we're all kind of implicated in this stuff. Our choices are few. Many of us can't opt out, or opting out is too much work. And really, we shouldn't have to. It shouldn't necessarily be our responsibility to come up with, or just to secure more just ways of operating in this kind of society and economy. Still, I think we should hope for or work for some kind of radical reinvention of how this stuff works, whether it's social networks without metrics, communications without surveillance, or business models that don't depend on personal data. I think that's unlikely to change anytime soon, but in my mind, if we want to restore some measure of privacy, or at least restore it as a cultural and social value, that's really the only way forward. So thank you very much.